here. And without further ado, I'm going to turn it over to Michael McConnell for introductory remarks.
Welcome. I'm Michael McConnell. I'm the director of the Constitutional Law Center here at Stanford and a professor at the law school. When I arrived at Michigan State University as a freshman in the 1970s, the campus wars over speech and sex were over, and speech and sex had won. Students could say whatever they wanted, however offensive, and often did, and the university was out of the business of chaperoning what happened in students' bedrooms. The change was incredibly fast, from parietal rules and civil decorum to, well, a situation where students were assumed to be fully formed, rights-bearing adults, and the university administration's authority over speech and sex on campus not much different from that of police and civil governments out in the world. Well, things are different again. I don't need to tell anybody that. Partly under pressure from the federal government, partly under pressure from student activists, and partly out of their own sense that something needed to be done to protect students, principally women and members of racial, ethnic, and sexual minorities, from speech that is stigmatizing and hurtful, and sexual encounters that are unwelcome and sometimes involuntary. So Stanford's Constitutional Law Center is an institution committed to providing a place, dare I call it a safe space, for serious discussion of hard and contentious issues. Civil liberty on campus is certainly one of those. So on behalf of the center, I welcome our distinguished speakers, both today and tomorrow, and our interested audience to what I think is going to be a lively and I hope illuminating discussion of these issues. Now I'm going to take off my hat as introducer and put on my hat as moderator for the first panel. And the first panel is on the topic of freedom of speech on campus. And we have a great panel. I am not, their biographies are in your materials. I am not going to read those. I'd like to get to their substance as quickly as possible. So just briefly, so you know who they are, on my immediate left is Greg Lukianoff. He is a Stanford Law School alum who is now the president and CEO of FIRE, that's the Foundation for Individual Rights in Education. I think it is the leading group that focuses upon freedom of speech and related issues on campus. He's also the author of a book entitled Unlearning Liberty, Campus Censorship and the End of American Debate and Freedom from Speech. Then on his left is Thane Rosenbaum, who is a distinguished fellow at the New York University School of Law, where he directs the Forum on Law, Culture, and Society. He is a novelist, an essayist, a law professor, and has a forthcoming book entitled The High Cost of Free Speech, Rethinking the First Amendment. On his left is Catherine Ross, professor of law from George Washington University Law School, currently a visiting scholar at the Harvard Graduate School of Education, and her latest book is entitled Lessons in Censorship, how schools and courts subvert students' First Amendment rights. Then we have my old friend Alexander Tsesis, who's just become, congratulations, Alex, the Raymond and Mary Simon Chair in Constitutional Law at Loyola, Chicago. He is a prolific writer on various issues of civil rights and with a heavy historical bent. One of his books, most pertinent to this panel, is entitled Destructive Messages, How Hate Speech Paves the Way for Harmful Social Movements. And then finally, on the extreme left,
extreme left. But you are right.
It depends, of course, on where you sit. Is Eugene Volokh, whom I first met when he was a law clerk for Justice O'Connor. I don't even remember how many years ago that was. He is the Gary T. Schwartz Professor of Law at UCLA School of Law, one of the nation's most prolific and leading writers on issues of freedom of speech, and perhaps best known today as the eponymous founder of one of the leading legal blogs, the Volokh Conspiracy. So welcome to you all, and they are going to go in alphabetical order, starting with Greg.
Great. Well, thanks for having me. It's nice to be back. I actually took a lot of classes in this room, and I never needed a mic before. But I just wanted to sort of lay the groundwork here a little bit by explaining the trends and history of free speech on campus a little bit for, I'd say, probably the last 20 or 30 years. And I started working at FIRE around 2001. I had worked at the ACLU of Northern California. Before that, I specialized in First Amendment law here. I took every class that Stanford offered, and then when I ran out of those, I did 6 credits on censorship during the Tudor dynasty. And nonetheless, I was absolutely shocked at how easy it is to get in trouble on the modern college campus. So I have to say that those of us who have been fighting this on college campuses for a long time, now that we notice that free speech issues on campus are suddenly so much in the news, we're like, where's everybody been? It's been pretty bad for a long time. And I have a theory on why, and I think it's primarily because the latest round is coming from, is partially at least coming from students. And I think that there's a little bit of when people, for one thing, love to hate the younger generation to a degree. But I want to talk about some of the trends that I've seen. Now first, the prehistory, just very quickly. A lot of people think of the heyday of speech codes. Maybe some of you haven't heard of these at all. First of all, there was no golden age for free speech on college campuses. There might have been some relatively good times like Michael was talking about, but it was never perfect. I sometimes joke that there might have been a perfect weekend in 1977 when everybody could say what they want before the old censorship ended and before the new began. But by the late 80s, universities were passing speech codes, and these codes were laughed at in the court of public opinion, and they were laughed out of court generally. From 1989 at University of Michigan, in a case called Doe v. Michigan, they were overturned, and then several cases later. The last of the set was actually at Stanford, in a case called Corey v. Stanford in 1995. And as best I can tell, the public, having seen these defeated consistently on college campuses, having seen these defeated in the court of public opinion, kind of wiped their hands and said, "Oof, thank goodness that's over." Well, what's really interesting is, and this isn't just our research, but we do really intensive research on this, amazingly, as it got clearer, legally speaking, that universities could not public universities could not maintain vague and broad speech codes, particularly ones that were just limited, that banned, for example, offensive or demeaning speech. And private universities in the state of California through something called the Leonard Law, even though that became clearer, the number of universities that had speech codes actually dramatically went up. This is something that other scholars have looked into, including, I think, William Gould. What's that?
John Gould.
John Gould, right. Found in 2000 that they'd gone up despite all of this, and our research said that he was actually underestimating this to a substantial degree. We have a constitutional lawyer who spends all day looking at campus speech codes and found a couple of years ago that about 75% of universities maintained what we call red light speech codes, codes that would be unconstitutional on a public college campus and would violate the idea of freedom of speech on private universities that claim to value freedom of speech. So the bulk of my career has not been fighting students. Actually, consistently, our most, generally, the constituency on campus that was the most pro-free speech was not the faculty, and certainly not the administration. It was actually the students. For most of my career, what we've been fighting is administrative overreach. Another stat that I think is interesting is that in 2005, the number of full-time administrators passed the number of full-time professors at universities for the first time, and that trend has just kept on going. So it should kind of come as no surprise as the army of administrators grows and grows, that life on college campuses become more bureaucratized. And people do try to color this very much in a political light. Certainly there is political correctness, certainly that's part of it. Certainly everybody likes to figure out, is this a conservative or liberal issue? But I have to tell you, an awful lot of it isn't all that political. An awful lot of it is, for example, the problem of speech zones on college campuses. About 1/6 of universities that we survey, public universities that we survey, have speech zones that are laughably unconstitutional, including Texas Tech University, which maintained a speech zone that was only, it was a free speech gazebo that was only, that was only 20 feet wide for all 28,000 students. So this is a nerd joke, but I went to law school with a guy who had a math degree from MIT. He graduated with me in 2000, and I had him do the dimensional analysis on what you'd have to do if all 28,000 students, God forbid, should want to exercise their free speech rights all at once, and he worked out that you'd have to crush them down the density of uranium-238. Now, as I said, about 1/6 of universities maintain this. They're particularly popular in California, where we've had 3 free speech zone lawsuits just in the past 2 years, including 2 separate public college incidents where students were told that they could not hand out copies of the Constitution outside the free speech zone, for which they had to get advance permission to use, or protest the NSA outside the free speech zone for which they had to get permission to use. Or at Cal Poly, for example, Pomona, down in LA, they not only told a student, a vegan and animal rights activist, that he had to get advance permission from the state in order to exercise his First Amendment rights, that he had to limit his advocacy to a tiny free speech zone, but he actually had to wear a badge explaining that he'd been granted these inalienable rights by administrators several weeks in advance. Completely creepy, and all of these are cases that we have litigated and ended in the death of the speech code. Now, also, sort of breaking out of the mold, an awful lot of these cases, as I said, are cases of just administrators not particularly liking a student or professor. I wrote a book called Unlearning Liberty. The main story of that is about a president, the opening story about that is about a student named Hayden Barnes. He was an environmentalist. He was mad about a proposed parking garage program at his school. He protested it, and he was kicked out of school with absolutely no due process whatsoever. It's a long case to explain. I'm not going to take the entire time, but the end result of it was a $1 million settlement, a nearly $1 million settlement with the Valdosta State University, and the violation was considered so bad that it actually was a situation in which the president was held to not qualify for the protections of qualified immunity. So those are cases that I feel like a lot of people wouldn't know about. But the ones that do better fit the sort of stereotype of the issue on free speech on campus are the abusive harassment codes. And so people understand, from 1989 to 1995, those speech codes that I was talking about that were ruled overbroad, pretty much, I think actually all of them were different versions of overbroad harassment codes. They called themselves harassment codes, but they banned victimizing in one case, they banned demeaning speech in another, all of which were ruled by courts to be too broad. So unsurprisingly, a lot of the cases that I see when universities are coming up with rationales for how to punish professors or students, they call it harassment, because nobody wants to say they're pro-harassment. But this leads to situations like one of the better known cases that FIRE has. Back in 2007, we had a student at Indiana University, Purdue University, Indianapolis, found guilty of racial harassment without so much as a hearing for reading a book called Notre Dame versus the Klan. Now, it was a book celebrating the defeat of the Klan when they marched on Notre Dame. It doesn't make it any more or less protected, it just makes the punishment more ironic. At Brandeis University, at virtually the same time, a professor was found guilty of racial harassment, again without a hearing, for explaining where the racial epithet wetback came from in his Latin American studies class. He, by the way, proceeded to then condemn the use of that word. I don't know how you understand the history of epithets if you can't actually utter them. And that's a case, by the way, that Brandeis University, a private university, but promises free speech in the glowing language of Louis Brandeis himself, should know better. But the second phase that I've dealt with in my career, and this is much more recent, is the newly aggressive OCR, Office of Civil Rights, the Department of Education, and newly aggressive Department of Justice. And this has only been since about 2011. They've been issuing increasingly difficult to comply with letters of clarification. A lot of these are considered to have to do with due process issues on campus. I'm sure they will be discussed tomorrow on the due process panel. But when they came to a settlement with University of Montana in 2013, they took out all the protections of around harassment, all the qualifications around harassment that make actual harassment as defined by the Supreme Court not such a threat to freedom of speech, and just said that harassment is any time any unwelcome speech of a sexual nature. That was the definition, and they consciously took out the requirement that that a reasonable person find it offensive. So anything that even you just subjectively, not a reasonable person would, but subjectively anything that you find unwelcome of a sexual nature is considered to be harassment under the blueprint. Now, if we can get that definition in court, we know it will be laughed out of court, but it's just difficult to sometimes take on these administrative agencies. We do have a case at Louisiana State University, thankfully, where they fired a professor citing the blueprint, which gives us the opportunity to show how vague and broad a standard like that holds up in court. So we're excited about that. But meanwhile, the Department of Education wrote me in a letter saying, sort of walking back some aspects of the blueprint. I made the point that you shouldn't be writing me, you should be writing every school in the country about this. And coming up with a much more reasonable definition of harassment. But just last week at University of New Mexico, the Department of Justice cited the university for a number of failings, not the least of which not having as their definition the blueprint definition of the Department of Education going back to 2013, the one that is laughably unconstitutional. So this is still going on. And I want to be clear, before I get to the last section, the third trend, is that it's not that these trends are going sequentially. They're additive. The administrative issues are still on campus. The desire to comply with impossibly broad and vague demands from the Department of Education is still going on, but you add to it students' demands for freedom from speech, which was the title of my most recent book. And we started to notice this really intensely around 2013, 2014, when there was a big spike in student activism to get speakers kicked off campus. Now, of course, again, the narrative on this is, oh, but it's mostly commencement speakers, and it only makes sense that people would not want to have someone that offends them speak on their special day. I disagree with that to a degree. But also at the same time, it wasn't, most of the cases that we dealt with weren't commencement speakers. They were simply inviting a controversial speaker to campus. And we saw that as a very negative trend, and it wasn't something that that actually put us at odds with students for the first time in my career. And then, of course, we get to all the sort of sexy things that have gotten us in the news more recently. Whether I wrote an article called Coddling of the American Mind with Jonathan Haidt for The Atlantic, where we talk about some of these things. And one of them is microaggressions, for example. And Eugene's going to talk, I think, probably a little bit more about these. But microaggressions are a theory that I think academically absolutely fascinating. But they're largely unconscious slights that you make that are either racist or sexist. But the problem is, as soon as you actually make this into an interesting academic cross-cultural miscommunication topic, into something you start policing, you run into real trouble. So UCLA has a microaggression policy that includes flat-out statements of political opinion, whether you think affirmative action is racist, or even things as what some might consider to be extremely innocuous. I think the most qualified person should get the job was an example that they gave as microaggressions at UCLA. At University of New Hampshire, they defined American as being a sort of quasi-microaggression. They also defined the use of the word Arab as a microaggression, which I found particularly offensive myself because I have Arab friends who aren't embarrassed to call themselves Arab. And I tried to point out that by calling that word all by itself a microaggression, that's kind of like what Michael Scott did in The Office when he asked Oscar, how do you self-identify? And Oscar very proudly says, well, I'm Mexican. And Michael says, ooh, is there a less offensive way to refer to you? So to be clear, microaggressions aren't just recommendations. They're being put into action by universities, including Ithaca College. And meanwhile, when I've talked to the dean of UC Irvine, he said, oh, no, we're not going to take any action on our ridiculously overbroad microaggressions program. And his answer was, well, we're not going to take any action on it. And my response was, you're calling these tiny forms of violence against the oppressed, and you're trying to claim you're not setting up an orthodoxy at UCLA. And these are very, very broad and vague terms. Trigger warnings, definitely I can talk more about those in questions if you have questions about them. I'm mostly opposed to making them mandatory, but in the Atlantic article I made the point that ultimately we think that those achieve the exact opposite of what people think in terms of mental health outcomes. But then the most recent trend were the fall of 2016 protests. Now the fall of 2016 protests for fire were a little bit of a mixed bag. Because one, we've been complaining to some degree about student apathy. While they were generally pro-free speech, they weren't very activist about it. And there was definitely a lack of apathy on campuses last fall. The problem was that a lot of the students were protesting for new speech codes. Not all of them, but a lot of them were protesting for more new speech codes, which we, of course, oppose. And we think is also wrong-headed, that you're not going to get the sort of progressive change you want by giving more power to administrators. And I have to say, despite the stereotype, this was actually the first time that we were largely put at odds with, in a lot of cases, African-American activists. And I want to, again, clear up stereotypes. For most of my career, there have been, overwhelmingly, minority students seem to understand free speech issues on campus better than almost anybody else. So I kind of thought of the fall as more or less an anomaly.
Thank you.
Good cut. Hello, everyone. Thank you all for attending today. I hope I'm not disappointing Michael and Judd, because I believe that I may have been invited here to defend trigger warnings and microaggressions and mob silencing and the disinviting of speakers and safe spaces, and I'm not here to do that, so I hope you'll still let me speak.
You're
Censored.
Your time is now over.
This is a free speech panel, and I should be permitted a chance to finish and explain, because there is some confusion, I suspect, because for years I've written about the obsession that Americans have with the First Amendment to the exclusion of other values, such as human dignity and mutual respect. And I've also called attention to the fact that speech actually creates harm. And I don't mean, when I mean harm, I'm not talking about hurtful words or insults or insensitivity or inflammatory language. I'm talking about harm, not just bruised feelings. I think it's important that we should start making those decisions. It's not feeling that you hurt my feelings, but you've harmed me. Speech has a way of being not just hate speech, but dangerous speech, because it causes harm to individuals, it can, and also paves the pathway to racial hatred and lynchings and pogroms and genocide, the incitement to harms. You know, by the way, the Europeans have figured this out, right? It's our obsession. Europeans also live with civil liberties. They also believe they live with civil societies, and they have much more stricter rules when it comes to speech. Now, maybe it's because Nazism was there and communism was near there, and we have the luxury, I would say the smugness, to not realize that speech, in fact, can dehumanize an entire group of people and desensitize your own citizens to the dehumanization that we perpetrate on other people. Words can harm in very, very eliminationist and dangerous ways. So it's, first of all, important to make these distinctions between hurt feelings and emotional harm. There are, by the way, studies that come out all the time from major universities showing that emotional harms are as injurious as physical harms. In fact, emotional harms can make a person physically sick. And here's something else. They're more long-lasting, right? And it's obvious. If you break your arm and then your arm heals and you go off into the world and you see someone wearing a cast on their arm, you don't freak out. It doesn't re-traumatize you. But broken people, however, people who have been subject to sexual assaults or violence or survived genocide, these people, in fact, are harmed permanently, and they can easily be re-traumatized. Free speech is not free, and it causes harm to many, many people, and many people pay a price for this freedom, and guess what? The people who pay this price are not usually the people that claim to be free speech absolutists. There seems to be a real connection. The free speech absolutists really have no idea what we're talking about, because it's just not what they do. They've simply not been victims of violent speech, and so that this is a perspective that they've completely missed. And in doing so, we've essentially overwhelmingly privileged this free speech right over the infliction of pain and harm that's sometimes caused by this speech. And we have to sometimes ask us, why do we do it? Why do we privilege speech? Why is this one area that both conservative and liberal jurists come together on? This is the one thing they believe in. In no other constitutional amendment do you get this kind of a consensus. What makes us so obsessed about this? I don't have time to talk about this today, but I have a new book coming out that will talk about this. But yet, having said all that, this is the point that I think would disappoint Michael, is that I am troubled by trigger warnings and microaggressions and safe spaces and disinviting speakers and silencing people through mobs. I think this is an epidemic that threatens academic freedom, and it really defeats the moral imperative of what a liberal education means. To be a liberal means to be open. It means to be open to competing ideas, contradictory ideas. It's being able to make distinctions between those ideas, to judge those ideas. This, by the way, reaches a very different discussion about the failure of liberalism in our universities. That there's the whole concept of being a liberal is just totally twisted and distorted, because to be a liberal means to be open, not to be shut off and closed off. But in fact, our universities have become places of illiberal thinking, and the liberal ideals of what are the essence of our democracy have been lost. All of these things, the trigger warnings and microaggressions, really are completely incompatible with what it means to receive a liberal arts education. Now again, I want to keep focusing on the difference between harm and offense. Because wherever I go, people go, oh, so you think that if I get insulted, I should just stop saying that word. I'm saying harmed, and they don't know what I'm talking about, because they've obviously, I don't know how this has happened, they've obviously never been humiliated. They've obviously never been exposed to real injury that comes through emotional harm. I've been teaching human rights for 23 years. So forgive me if I tell you that I'm worried about macroaggressions. That's where my head is at. That's where I roll. I roll with the macroaggression. I don't want to insult the people that have been exposed to macroaggressions by even using words like microaggressions. I'm talking about objectively serious assaults on humanity. And I would think at a university, that's where our head should be focused on, at least some of the time. Now, with respect to trigger warnings, I read Greg's article, which I recommend you all read. It's fabulous, and I'll mention it again in a moment. But I will say that the trigger warnings, to me, I have less feelings about. I think if you want to warn your students that they're about to read a novel in which there's a sexual assault, if it's done for the purposes of giving them a heads up or a cautionary warning, I think that's totally fair. Greg and I have different views on that. He raises some interesting points on the psychological literature. But I'll tell you that where the problem becomes is where people believe that trigger warnings should be used as a prophylactic, not as a warning, but a prophylactic, something they can cover themselves in and shut themselves off from ideas. Students simply cannot be allowed to hold a veto power over the syllabus. And that's what we've done. We've given them veto power over the syllabus. I have no idea, but I think it's time for the faculty to take that back. By doing this, we're really simply trivializing real aggressions, where speech is in fact violent and causes actual harms. And to point out the extremes, let's go to the micros themselves to show you how micro this sometimes is. Some of this is in Greg's article in The Atlantic. Please read it. It's wonderful. In 2013 at UCLA, I'm going to give you two UCLA examples because we're in California and I'm a New Yorker, so I'm having fun out here. And there was a student protest, a sit-in for a professor who corrected the grammar of a student who took the word indigenous and gave it a lowercase I. Because, no, the student gave it an uppercase I. And the professor corrected it and gave it the lowercase I, because it should have been a lowercase I. The student gave it the elevated capitalization. And so the paper came back with the correction, and the student mounted a protest claiming that the changing of the capital to the lowercase insulted her ideology. And this was accepted as, of course, that's a microaggression, of course. My favorite one, really, at UCLA, it shouldn't be my favorite, I don't know what this says about me, was a costume party that a fraternity undertook that had a Kanye West, Kim Kardashian theme. And so many of the frat brothers dressed in saggy jeans and put a lot of bling around them, you know, along their chains, and maybe a baseball cap turned backwards. And this was deemed, you know, and basically a misappropriation of hip-hop culture, a cultural insensitivity to African Americans, and utterly just a misappropriation. And I'm thinking, There's genocides going on in Darfur, in the Congo, mass killings in Syria. We're having this kind of a conversation. This is the kind of violence that we're allowing students. We're actually taking them seriously. We're actually saying, of course, by dressing like a rapper, I've insulted you. Of course, I understand it. And everyone apologized. I think the fraternity was suspended briefly, right? They were suspended briefly. They had to make a public apology, how horrible they were to do this. By the way, it was a Kanye West costume party, and that's something I would have liked to have been invited to. And I would have dressed as Taylor Swift. Because, Taylor and I have very similar coloring, and I could have gotten away with that microaggression, I think. Look, there are, in fact, dangerous, damaging, harm-producing speech actions in our world, and certainly on campus, that are really, truly aggressive, not microaggressive. And I actually think there's nothing wrong with regulating and punishing them. Mark Yudof, who will be speaking tomorrow, right, Michael and Jed, speaking tomorrow. He was, in 2010, he was the chancellor of the University of California system. And he faced two situations that year, one at the University of San Diego, in which a noose was hanging from the library, and another situation where a Jewish student's door in the dorm room had a swastika carved into it. And in both cases, the students were suspended and punished, and I think that's absolutely appropriate. At the University of Mississippi, there was a noose hanging on the statue of James Meredith, the first African-American admitted to the university. Why? Well, these are harms. These are not just, this is really speaking to historical injustices, historical atrocities. These are personal attacks against people that are supposed to be made feel welcome in a university setting, in a university community. The Kanye West story, to me, is a mini microaggression. It's not even anything. I can't even believe I even told you it. It's insulting that I mentioned it to you, but these students were all punished for it. Here's another one. I don't know how you feel about this. Louisville University, University of Louisville. The president of the university, this is the president, hosted a Halloween party. Halloween's very important in our country, in universities. Even the presidents host these parties. And this was a Mexican-themed party. So all of his guests, the president's guests, dressed with sombreros. And he had to apologize because of the sombreros. This was culturally insensitive. They had misappropriated the hats of the Mexican people. I'm a Jewish American, and I have to say, if you're a fraternity and if you want to dress up as Hasidim, if you want to do that, and I don't know how the Hasidim feel about this, but if you want to dress in a long black coat and have tzitzis and payas, and I just think that there are more important things in the world, and that this is a very different idea. Now, on the other hand, let me just say this, and I want to see how you feel about this. If a fraternity had a costume party and they dressed up in chains on their ankles and wrists to evoke slavery in the United States, if they dressed up in Indian headdresses with tears coming down their eyes to evoke the Trail of Tears, if they had dressed up in striped uniforms to evoke concentration camp, death camp uniforms, this is something I don't think civil society should accept. And I think it's totally appropriate. This idea of free speech is utterly nonsense. We don't invite the Klan to the universities to speak because we believe that everyone has the right to speech. We make distinctions. We're allowed. We're grown-ups. We understand that there's some things that are acceptable in our society and some things that we simply are not. And the reason these things are important is because, again, they evoke a kind of historical atrocity and an injustice, and they're essentially their personal attacks. This is conduct. We shouldn't use the First Amendment to protect conduct that's essentially designed to harm people and to cause hatred. Hate is not an idea. I'm getting there. Hate is simply not an idea in the marketplace of ideas. It's simply hate that's designed to harm. And it's not made respectable simply by granting it the status of an idea. In this marketplace of ideas, we're so lenient and we're so permissive and so cavalier when it comes to speech. But not everything that comes out of someone's mouth is an idea. Sometimes what comes out of a person's mouth is vomit. And we need to not be afraid to make those distinctions. And I think it's also important to understand that when we speak about making that people exercising their free speech rights, that shouldn't be used in a way to make others feel less free. This is the smugness of the First Amendment, that it can be used to make others less free. And then finally, yes, people have rights to free speech, but there's also the rights and responsibilities that come with citizenship. And I think the Founding Fathers understood that as well. Thank you.
I have a point of clarification because it's funny.
If it's funny, yes.
It's not funny if you say it's funny.
Actually, the theme, I think it still will be. Actually, the theme of the party was a Kanye Western. So they tried to combine Western themes with Kanye West and Kim Kardashian. And one of the things that some people got in trouble for is they dressed up as gold diggers, a tribute to the song Gold Digger. And people claimed that was racist because they were wearing baggy pants. And it's like, no, but they actually...
I think the accusation was that they were wearing blackface. And they said,
they had dirt on
Well,
their
I didn't hear anybody laugh. So we're going to...
No, here's one that makes you laugh.
We're going to move on.
The Armenians were not upset by the use of Kim Kardashian because some of the people were dressed with big butts. And some people thought that this was mocking of African Americans when it was supposed to be mocking of Kim Kardashian. And then when people wondered, well, how come the Armenians aren't upset?
Well,
I think her existence is an insult to Armenians.
One of these days, somebody's going to have to explain to me who the Kardashians are. So, Catherine Ross.
Okay. Well, I'm going to take a somewhat more legalistic and therefore perhaps less entertaining route than Thane. And that will explain some of our, or perhaps most of our differences with respect to hate speech. Because what I'm talking about is bound by our First Amendment doctrine rather than what might be, as Elena Kagan said when she was still a law professor, a reasonable system which would allow a hate speech code on a university campus to survive scrutiny. She said that isn't our constitutional system. So I want to begin with what is the purpose of an education, or what we might call a liberal education. And there are 3 model speech codes for universities that are not codes in the sense of saying the following speech is forbidden and will be punished, but rather how should a university create an atmosphere in which free speech can flourish, and free speech, of course, having at its core protection of the dissident, the person who is not politically correct in whatever the current climate is, the one who seeks serious social change, or the one who's just kind of a nudge. The codes that I regard as really worthy of emulation are the ones written by First Amendment scholar Harry Calvin at the University of Chicago, by a committee chaired by C. Van Woodward, the historian of the South at Yale in the early 1970s, and most recently by First Amendment scholar Jeffrey Stone, again at the University of Chicago. And each of them emphasized that universities are here to promote the discovery and dissemination of knowledge, and to protect freedom of expression and the diversity of viewpoints, which they saw as being at the core of the mission of any serious university. Calvin wrote, "A good university, like Socrates, will be upsetting." And this is a very different view of a safe space than the one that seems to prevail in the discussions in 2016. It's a safe space for wide-ranging expression, for divergent views, and for the airing of controversy. If scholarship is to be tested, it's going to be tested by professional norms. And here's a place where I agree with Stanley Fish. But if students want to test their own beliefs, and they're developing emerging sense of values and what's important as they separate from their families of origin, late adolescence is a time of testing boundaries, testing identities, and they need the freedom to do that. Some may utter words they later disavow. And they also need to learn how to disagree in an effective way that respects everybody's expressive rights. But in an article in Dissent just this week, a Georgetown historian wrote, each campus has to decide if regulating free speech is the best choice for its own community. I could not disagree more vehemently. For public universities, they're bound by the First Amendment. And as Greg pointed out, many of our best private universities, perhaps all of them, have undertaken to respect free speech. And the only way that we can measure whether they're doing that is by applying First Amendment doctrines and norms. And here I exclude the colleges that have singled themselves out, often sectarian colleges, and say, we're not bound by that. We actually have a preferred viewpoint, and we have rules that enforce that viewpoint, and if they're private colleges, they're entitled to do that. But I'm going to speak now as if these First Amendment rules and norms apply pretty much everywhere. So it's important to distinguish who's speaking, in other words, whose speech are we proposing to limit, the context in which it takes place, and who is doing the abridging or advocating that the speech be abridged. And here I share Greg's alarm that it is now the students who seem to often be seeking to abridge the speech not only of their professors, but also of their peers. And we have to ask, where did students get the idea that they can and should be protected from speech they find offensive, whether because they find it personally hurtful, or they disagree with it, or even if they're altruistically thinking it might offend someone else? And one of the answers, I think, is that the schools they attended in grades K through 12, and 90% of our students in the US go to public schools bound by the First Amendment, these schools have failed in one of their traditional functions, which is to teach the shared norms of citizenship, including the meaning and value of the First Amendment. And they have failed not only by failing to offer civics classes, something a lot of people have talked about, but also, as I show in my recent book, by failing to respect the constitutional rights of students themselves to express themselves in school. Now, it is true that the Supreme Court has crafted a special doctrine that allows public schools, when I use that term, I'm talking K through 12, not universities, to regulate student speech that could not be regulated outside of school for adults. And they can do so on several grounds. The most important is when the speech comes from the student, him or herself. The school can only regulate it or punish it, in other words, prevent it or punish it after the fact, if the school has grounds to anticipate that the speech will cause material disruption. In other words, it will interfere with the carrying out of the school's educational function. Schools may also discipline speech that is lewd or that appears to advocate the use of illegal substances and lacks a political message. So students can say, we should legalize marijuana in this state, but they can't say everybody should be doing dope before first period. And finally, and this is a very large exception, schools may regulate speech that is school-sponsored, that appears to bear the school's imprimatur, or as Justice Alito said when he was on the Third Circuit, speech that appears to be the school's own. But even there, they have to first show that it meets the definition, that reasonable people would think the school had approved it. They also have to have a legitimate pedagogical reason. But too often in grades K through 12, officials trample students' First Amendment rights because they don't understand them or they simply don't agree that students should have these rights. And by doing that, they not only deprive students of the opportunity to learn to understand why we must hear offensive speech and how to respond to offensive speech, but they also convey the message that we don't mean what we say as a democracy, that these are just words in some old document that don't affect our lives today and that don't provide meaningful rights. And I'll say more about that. But as one student said, my school is all about censorship. That is the lesson they are learning before they get to college. So that is one of the reasons that the recent Pew survey showed that 40% of college-age students thought it was just fine to limit speech that offends minorities. That is not what our Constitution says. As hurtful and even harmful, and the risks that such speech will be translated into action, our Constitution says we can regulate the conduct. And sometimes we can anticipate it. And I would just say, in terms of Thane's examples of the swastika on the Jewish student's door, that may well be a true threat, a narrow constitutional doctrine that can always be punished. If the Jewish student inside that room took that as a real threat, which they probably did, it might well have met that definition. So how do I relate this to some of the topics we've been talking about? Trigger warnings. Students, for the most part, didn't hear controversial ideas in their school classrooms because teachers are increasingly not allowed to bring controversial ideas into the classroom, either through supplementary materials that have not been approved or by challenging the ideas in the textbook that the school board selected. But as one federal judge said in a case involving a controversial book that a teacher introduced, the reaction to controversial materials is what makes them worth teaching. But students didn't learn that. Similarly, microaggressions. The issue, and I share, I agree with everything that Thane said about microaggressions. There are far more serious things in the world that we should be concerned about. And there are also verbal macroaggressions that we could deal with, but aren't. But the issue isn't whether students today are hypersensitive. Undoubtedly, some aren't and some are. But the issue is they didn't understand or learn that they can't be protected from offensive words under the Constitution. There is no right to be protected from offensive ideas or even non-ideas, because the speech clause protects even silly and dumb ideas that don't make a big contribution, because who is going to do the sorting of which ideas are important enough or political enough to be protected? So they may be nonsense. And then students also want to go after gestures and physical postures that convey offense, even if unintended. How are we going to go about monitoring that? This is just so far over the line, it shows they don't even begin to process notions of expression. What we can do is teach students in K through 12 and in universities, how do you respond to offensive speech or even gestures? You can ignore it, you can walk away, you respond, you drown it out with more and better speech, as the Supreme Court has long told us. And then the concern about the heckler's veto, which is really the origin of keeping the speaker off campus. Our constitutional doctrine has long said When there are hecklers, when there's a mob, the state protects the speaker and breaks up the mob. But too often students have seen that if they object enough, if they create a risk of disorder in their lower schools and in colleges, the administration will silence the speaker. So the high schools have recently, in several dramatic examples, removed peers from the campus when they said something that other students found objectionable, even when the other students were making threats against the speaker's lives. In one case from East Hampton, New York, this young man had actually just repeated something he'd heard that someone else had said. It wasn't even his view. It offended the largely Hispanic population of his school. Death threats were made. He was removed from school for the rest of the academic year, which unfortunately this happened in September. He was out of school all year, and the next year he had to move to another state. Actually, he's living somewhere near here. I don't know where he is. He moved to California because the school said, we can only send you a tutor at home. We cannot control the people who wish to harm you because you said something that they thought attacked Mexican Americans, and we won't give you the opportunity to explain yourself. The other students understood that since he was removed from school, he probably had in fact said what people thought he'd said and meant it. Many years later, the courts said his speech rights were violated, but that did not restore his life to him. And I think the heckler's veto has really become ascendant in too many of these speech situations, including in universities.
Thank you.
Thank you so much. Thank you for Mike McConnell and to Judge Campbell for inviting me. I'm deeply grateful by the opportunity to speak about this pressing subject. Obviously, the debates on campus speech codes have been around for decades, and the camps are very far set apart. They go all the way from David Bernstein, who believes that any campus speech codes would have totalitarian implications, to Erwin Chemerinsky, who believes that a public university simply cannot prohibit expression of hate, including anti-Semitism, without running afoul of the First Amendment. To me, these are both exaggerated and in many ways absolutist, but I'll talk about that in just a little while. And then, of course, there are lower court opinions. In part, Greg Lukianoff spoke about some of them that found certain campus speech codes to be unconstitutional, the one he mentioned in Stanford and Michigan. The problem with these sorts of criticisms often are that they don't distinguish quite well. So the case in Michigan was very different from the case in Stanford. In fact, the speech code was quite different, and the nuances are very important. In Michigan, the coach said to the players that they're niggers and that they need to play. That seems to be very offensive to me. And on the other hand, in Stanford, the controversy was whether a group of students discussing whether or not Ludwig van Beethoven was black, which doesn't seem offensive at all. It's the equivalent of speaking about what Jesus Christ looked like.
The case that involved the N-word, though, was Central Michigan University. The one I was referring to was Dovey, Michigan, 1989. Oh. Okay. Sorry.
So anyway, that makes the point. See, we misunderstood each other of which case we were talking about. The point is that these are nuanced situations, nuanced speech codes, so that on the flip side of David Bernstein and Erwin Chemerinsky are the group of people who believe that equality and equal protection are relevant, the effects that the speech has on students on campus, and they too sometimes take pretty extreme positions that sound like, kind of taking the position to its without looking at the effects and how it might impact speech more generally on campus. So, the microaggression stuff that's going on right now, first of all, when you hear about this as an audience, if you haven't done the research, it seems like a really big deal, doesn't it? But in reality, the trigger warnings, which we've heard several people speak about, right? Only 1% of people in a recent poll, professors, are on campuses where there are such trigger warning requirements. 1%. Is that really significant? And then what about as to who is particularly bringing it forth? It's absolutely true it's students, but the professors indicate that it's about 13.5 to 15% of the students. That is not a very significant amount of people. Students do understand the significance of speech, is what I would think of this. Although the microaggression, of course, the stuff that's out there, I mean, you know, not asking somebody which country they come from and where are you from. In fact, I mean, that clearly sounds like, you know, to suppress, to punish seems the utmost of absurdity to me. So where am I going with all of this? I'm going with this to say that the proper parameters of a campus speech code should be First Amendment doctrine. There are some barriers, there's no question about it. The most recent ones being the courts Justice Scalia's initially created and just recently Justice Thomas's repeated expression that there's no such thing as viewpoint discrimination, which is allowed under the First Amendment. Alana Kagan, when she was a faculty member, explained that that's incorrect. Even obscenity, even fraud involve certain social considerations. There are actually a variety of content restrictions that are allowed under the First Amendment. Things like my not being able to give advice and pretending like I'm an attorney if I am not. I cannot give advice and pretend like I'm a physician if I am not. I cannot do cross-burning. I'll talk about that in just a little while. I can't do intentionally threatening things. Those are all content-based. If I tell somebody, I am a physician, here's my advice, that can be regulated, that can be prohibited. So one barrier that we have is Supreme Court doctrine itself, where the Supreme Court disingenuinely pretends that content regulations on a whole are prohibited. Other things that are much more pertinent than copyright violation, although that too is pertinent on campus, to a university setting, are sexism in a workplace. Sexism or xenophobia or bigotry in a workplace. We can prohibit all of those things, right? Why we want a non-harassing, safe environment seems very, very reasonable to us. Those things have been challenged on the First Amendment, and that those settings have been found to be legitimate. And I would argue that the campus has some close links to that. Now, I am going to go into First Amendment doctrine. That's actually going to be the meaty point. I have to move quickly to leave myself enough time, because I do want to talk about, we've heard about, I think every example that Thane gave and that Greg gave are ones that I would agree with. I mean, they seem over the top and abusive, but there's another side of the story, and that is the strength of student movements to create violence and harm. In Rwanda, calling the Tutsis cockroaches on campuses, marching around and in favor of the Bahutu movement had a serious impact in indoctrinating and making people feel comfortable with murder. And the same was true certainly in Germany. In Nazi Germany, where Jews were, pre-Nazi Germany, under the Adolf Stoker movement, where Jews were kept out of fencing clubs, and the university and university student bodies were instrumental in developing leaders who later became politicians. The same was true certainly in Indonesia with the Kami movement, which means that formed all sorts of anti-communist student groups who were critical for the anti-Sukarno demonstrations and cooperated with the armed forces in ousting President Sukarno. They were horribly violent. The Cultural Revolution the students played a major role with the Red Guards and the extreme violence that they visited. So we shouldn't pretend that universities are completely, that student organizations can be completely benign. So what's going on around the country? We've heard of these absurd cases. I didn't hear one that I disagreed with. But we know that in the example was given about the swastika being scrawled. There are also anti-Palestinian messages that appeared scrawled on campus buildings at California Polytech the example of the Confederate symbols, the noose hanging. There are Confederate symbols in other in other parts of the country, in grammar schools and high schools as well. Also a symbol clearly of slavery and violence. In Eugene, Oregon, there are several hate speech related crimes on campus. There was about invitations. We talk about invitations to universities. Well, David Irving was invited to them. A Ku Klux Klan supporter, Tomislav Sunak, was invited to the University of Oregon campus. Can we not disinvite those people? They are supporting violence and complete fraud with Holocaust denial. There's all sorts of antagonism that's occurring. In UC Berkeley, students report a friend wearing a yarmulke walking to a library and somebody saying Hitler was right. The Student Justice for Palestine movement, there's a report of somebody calling people a Zionist kike. I mean, are we really, those are really benign. Those are not hostile. Those do not make people uncomfortable. Those do not keep people from moving around on campus and avoiding specific places that they think are a concern to them. So part of the mission of the university is civility, of course. First of all, the campus speech codes, unfortunately, there are all sorts of them. There are ones that have intent component, negligence components. Even the one that we talked about, the University of Chicago, which Fire credited, has itself acknowledges, the one that was mentioned that Jeff Stone created, has points where it acknowledges the fact that harassment is a legitimate thing that can be prohibited, as well as defamation. I'll find that later on. But so what are the parameters that I am recommending? How can we make certain not to undo things that are beyond the threat, beyond constitutional measure? I think that we should use three principal doctrines of the First Amendment. The first is the incitement doctrine, putting someone into imminent threat of harm. The second one is the true threats doctrine. I do not agree, I agree with many things Catherine said. I did not agree with the point that a person has to feel threatened. That's not in the Supreme Court test. The Supreme Court test is a person has to intentionally direct, has to intentionally make statements where the speaker means to communicate a serious expression of unlawful violence to a particular individual or group of individuals. The University of Chicago Code only speaks about an individual being defamed. The United States Supreme Court speaks about a group of individuals.
Just point of clarification, the circuits are split, and some say it's an objective standard, and some say there's a subjective component. Yep. And the court hasn't clarified it.
Yeah, I think it's pretty clear. There's a brief written by Robert Post and Jack Balkin joined it. I think it's pretty clear. It's I don't see how, whatever that we can talk about. The other one is the material support for terror statute, one that's unlikely to be pertinent in a campus, being because it would involve coordinated conduct with a foreign terrorist organization, but engaging with a terrorist organization like the Klan, it's not within the definition of material support, but one that I would question as having First Amendment validity. There are other methods to use, the Title VI codes against campus hostility, against making a hostile environment, one that I think is very closely allied to the Title VII matters that I mentioned before. So the purpose of this is to create a civil environment where communication can be about controversial matters, matters of deep disagreement, but one where students do not feel like there is an incitement to violence, they do not feel threatened, and they do not feel like there is a legitimation on the part of the university of type of extreme cases of statements. So I'll give an example of one thing where this conversation typically goes is it speaks about punishments as being things like suspension or complete removal from campus, whereas there are much lighter punishments that are possible, right? There is, first of all, the ability to communicate ideas, that is to say, something allied with government speech and the government being able to present its own message. There is reprimands that are simply verbal reprimands, so that students understand what the position is on hatred and civility in a university. There is trying to get community service. There is trying to bring students together. All those things seem possible. And I'll give an example, particularly to show the pertinence of my point. Just recently, the University of California, something that many of you probably have heard about, is this question, Professor Volokh was involved in this as well, about whether or not there should be a statement of anti-Semitism, that the university opposed specifically anti-Semitism. I think that this was the right thing to do by the regents. In part, that's because many of the campus speech codes that are out there, for example, the University of Wisconsin, which speaks about human dignity and prohibits harassment on the basis of race, sex, religion, color, creed, disability, sexual orientation, gender, national origin, ancestry, or age, simply doesn't have Jews in it, right? Jews are not a race. They're not a religion necessarily. There are religious Jews. There are Jews who are religious who would not say that they're not Jews. You know, they're Roman Catholics or whatever. They're not a national origin because, you know, they come from all sorts of nations. And so that, and not only that, we're talking about the deepest, furthest extension of hatred that has occurred throughout countries. And the statement, the communication that was made by the university is as much as making a statement against sexist speech, racist speech, which singles out a particular form of speech as being wrong. And so that it seems just as legitimate for me to single out the anti-Semitism as another form of extreme speech that there's no punishment to it. It's just a verbal statement, but government speech only requires rational basis to be upheld. So thank you so much for your time.
Alexander and Catherine, can I ask you to move a little bit because I need to plug this in, and it turns out that this requires me to
We're very cozy.
Yeah.
Very cozy here.
There it is. So now, the only thing, John, where was John?
Oh.
He was there a moment ago. So the only question is how to switch so that it actually accesses that. Do I hit escape somehow?
Oh, yeah.
All right. So now it should be on the.
I think I can move back a little now.
Yeah.
All right. So you can tell this is my kid's thumb drive. Sam, perseverance. Yes, Sam, it's very important. Okay. All right. I was told that I need to direct this there. Is that right? Okay. Thank you very much for having me here. It's a great pleasure to be here and to talk about the subject, which I find very interesting and important. People have covered a lot of territory. I want to give a few examples and actually key off of this point of harm. You know, I'm actually a big believer that speech causes a great deal of harm. Try to communicate that to my students in class. And one of the things that most annoys me is when people sort of say, well, speech is protected because after all, it only does good things. Well, that's bunk. And one way that I tell them that is, don't think about the particular statement. Because for any statement, you could say, well, what are the chances this statement will be the one to do something, cause something bad? Think about virtually everything bad that's done. The 9/11 attacks, they were caused by speech. Somebody must have, people don't, some things aren't caused by speech. For example, trying to rob someone. You know, they could say that's sort of a natural human tendency to want stuff that isn't your own. But religiously motivated mass slaughters or politically motivated mass slaughters, by definition, are motivated by religion and politics. It usually takes some speaker out there who will actually get people to do these things. Communist violence, Nazi violence, all sorts of such things. Inevitably, there's speech at the bottom. So I understand the reasons why people want to restrict speech that they see as causing harm. Problem is these restrictions cause, I think, a great deal of harm themselves. And let me give a few examples, all of which I think were motivated by people who really thought they were trying to prevent not just offense, although that word is sometimes used, but harm. So let's start with moot court. Most of you here probably know a lot about moot courts. Take it it's a very lawyer-heavy audience. This happened at a top 25 law school in the country. Not long ago, when the Alonis case was pending, we heard a little bit about the threats doctrine, and the Supreme Court in the Alonis case was actually supposed to decide. It didn't decide because of statutory reasons, but it was supposed to decide whether the true threats exception extends to speech, only that speech that it has the purpose of putting people in fear, or also, that's the objective alternative, is any speech that a reasonable person would perceive as threatening. So what had happened was in Virginia v. Black back in 2003, which involved cross-burning, which said some cross-burning is protected, but others is not. Talked about the objective standard, the sense that that speech wasn't a punishable true threat unless it was actually had the purpose of causing harm. But it talked about it kind of offhandedly. And as a result, there developed a circuit split which remains unresolved on that very issue. So while the case was pending, it was understandable that the students wanted to have this be their moot court problem. And here's what happened. As with many moot court programs, there was a faculty advisor, and I think that's a very good idea because I think it's good to have faculty advice on. And the faculty advisor said, if you want to have this program, you cannot include Virginia v. Black in the course, in the reading materials. This is, by the way, one of those closed moot court programs where people couldn't do their own research. They were given preset research. So the goal was simply for them to write a brief based on that rather than research it and then argue it. Why not? Because it involved cross-burning. And students, black students would be, and I'm pretty sure that the perception on the administrator's part, would be harmed by reading a case about cross-burning. And then they said, well, wait a minute, this is the leading precedent. Well, no, you have to exclude it. But wait, there are other cases out there that we would include, therefore, but all of them must have cited Virginia v. Black because there were lower court cases that caused a split. Why? Because they were citing Virginia v. Black. They must have talked about the facts. Well, you have to redact the facts of Virginia v. Black from that case. You laugh. 3 administrators they appealed to. All 3 of them, so a total of 4, said, yep, you cannot include Virginia v. Black in the course pack to prevent harm. Ultimately, what happened was they did one more appeal with the help of a friendly faculty member to another administrator who was actually an administrator who came from the tenured faculty, whose reaction was, this is ridiculous. This is a law school. We're a law school. We're supposed to be talking about these cases, and a lot of the cases involve really bad behavior, so that's life of the lawyer. It was reversed. I will tell you, to the students' credit, the credit of this, the black student group and other students, I don't think anybody objected to that once it actually happened. It was all anticipatory concern on the part of the administration. Now, I think if somebody had just gave you this as a hypo, you'd have said, oh, this is just one of those ridiculous things, Rush Limbaugh, if you knew about moot court, would make up. But it happened. That's the thing. It's a strange path we've come to where this kind of thing could happen. Let me move on to another example. So following the Charlie Hebdo murders, which again themselves were caused by speech, and I don't mean caused by the Charlie Hebdo cover, people don't go out there and murder people this way unless they have been caused to do this, or I shouldn't say caused, urged to do this, and had an environment created for them in which they could feel they could do this as a result of harm-producing speech. So in any event, this is the University of Minnesota, there was a panel that was put together by faculty members it was titled, Can One Laugh at Everything? Satire and Free Speech After Charlie. And they had the cover of the Charlie Hebdo post-massacre edition, because after all, that's what they were talking about. So Kimberly Hewitt, the director of the Equal Opportunity and Affirmative Action Office, got involved because there were complaints made. She says, well, there are limits on free speech, and that would be wherever you have harassment. This is the harassment logic that sometimes is praised of an individual based on their identity. Now, some defenses of harassment is, well, if somebody singles out a particular person and starts following them around, shouting at them, shouldn't that be punishable? Well, maybe under certain circumstances. but look how easy it is to slip from harassment of an individual based on their identity to this cover. They didn't talk about any of the students. This was a cover from Paris that was then being talked about by the faculty. But that somehow becomes harassment based on identity. We got complaints from 8 individuals in a petition from 300 people saying they felt this was insulting, disparaging to their faith. Now, they used the word insulting, but I think they could have used the word harmful. I don't think it's a stretch of the concept of harm under some loose enough sense. To say that when something is done that you perceive as blasphemous, as injurious to this religion, that you consider a key part of your identity, that would be, you might see that as harmful. You could say that. I don't think that that should affect our ability to talk about these things and display this. Well, the investigation proceeded. Now, the college dean, I think, did the right thing. There was an email asking the flyers be taken down. The dean said, there was an email sent by an administrator saying that the flyers should be taken down. The dean promptly reversed this. Well, so here's the reaction of the University Equal Opportunity and Affirmative Action Office. Investigation concludes the flyer does not rise to the level of discriminatory harassment, but that because many people found the poster personally offensive and hurtful, contributed an atmosphere of disrespect towards Muslims, and recommended that the dean communicate the College of Liberal Arts does not support the flyer's image of the Charlie Hebdo depiction of Muhammad. Now, I personally do support the flyer's depiction of that. I would actually affirmatively communicate to as many people as are willing to hear that I actively support this. I probably wouldn't do this as a dean, except insofar as saying that I support the free speech right to do this, because I don't think the dean's role is to take a stand on these things. But they were seeking that the dean take a stand against the faculty using depicting one of the most important kind of historical cultural documents of the modern era, that cover of Charlie Hebdo, because some people find it harmful based on their own ideology and their own religious beliefs. So let me move on to something that was circulated at UC as a proposed statement of principles of tolerance and respect. Hey, who's against tolerance and respect? Talk about note how it's articulated. It's not just that we want to speak out against something. We're saying there's a right. We as the administration, we as the employers, we as the disciplinary apparatus, say there's a right for people to work free from, not from discrimination as such, in the sense of being, say, fired, or being given poor grades because of their race or religion, free from expressions of intolerance. You have a right to be free from those expressions. Now, of course, a lot depends on what is meant by intolerance. If it means right to be free from expressions that I'm going to kill you, well, I do think you have a right to be free from that. I do believe in the true threats exception. But let's see what they meant by intolerance. They had a list. Here's one. Depicting or articulating a view of ethnic or racial groups as less ambitious, less hardworking or talented, or more threatening than other groups. Now, a lot of such statements that would fall in that category are ones I would disagree with, and some I would disagree with quite bitterly. Others, it seems to me, are perfectly plausible things for a university to discuss. We know that there are very substantial differences in, say, in income and education levels between various racial groups, between blacks and Hispanics and whites and Asians, and within each group there are subgroups. People are constantly talking about what the causes are. One common argument is it all caused by discrimination. Perfectly plausible argument, maybe quite right. Another argument is it's caused by genetic differences between those groups. Now, my understanding, I'm not an expert on the field, my understanding of people who study this field, that's probably wrong. Another argument is, well, it's caused by cultural differences between groups. So, for example, say, Chinese Americans perform better in some respects than Caucasians because of certain cultural attributes. And also an interesting question. How much of which one is true? We can't know unless people are free to talk about this. Once the university, the employer, the administrator tells people these things violate people's right to be free from expression of such statements. These things are things that are contrary to our values, and hey, if you're an untenured faculty member, if you're a TA or a grad student, you're going to get the message from that. These are things you can't talk about. The interesting thing is if you can't talk about them, then you can't even conclude fairly, honestly say that the things that you criticize are wrong. Even if you firmly believe that every single difference in economic, say, success between racial and ethnic groups in America is solely caused by discrimination against racial minorities, you may be perfectly right. But you can't know that you're right unless the contrary views have been aired and the best arguments have been given, and you've heard them and others have heard them and have concluded that those are unsound. So this is essentially ruling off the table very important arguments about very important issues. Well, that's one of the things. Here's another one. Depicting or articulating a view of people with disabilities, both visible and invisible, as incapable. I'm not a big believer in kind of renaming terms, saying you can't say handicapped, you have to say disabled or people with disability. I don't go for that. But I do remember there was a talk by by an advocate who said, you know, what we should do is we should rename people who aren't handicapped. We should call them the temporarily able-bodied. And I think there's a lot of wisdom there. I'm going to have a disability one day unless I die young. Or I can't die young anymore, unfortunately. The disability is a reality of life. But one of the things that makes a lot of them so tragic is precisely that they render us incapable. Now, I do agree that you shouldn't just say, well, this person is disabled in a particular way, he's in a wheelchair, therefore he can't hold down a job. Obviously, that's ridiculous, and we see lots of examples of people who actually overcome their disabilities and do things that we're very surprised that they're capable of, but we're very capable of. These are very reasonable points, and there's a reasonable debate to be had about the degree to which disability law should accommodate disabilities and mandate the accommodation of disabilities. I actually am not a big supporter of reasonable accommodation doctrine under disability law, but it's a very interesting question. But this is almost Kafkaesque. To say that at university, it's not just that you can't say things that, you know, are important for us to talk about, might be right, but maybe not. You can't even say things that are literally true, which is people with disabilities are indeed, at least as to certain things, incapable of it. That is often what we mean by disability. Again, you want to hedge it. You don't want to make overbroad statements, either that statement or the opposite statement. That's just an important fact of life in a university, that you shouldn't make statements that go beyond what the evidence can support. But something like this, it seems to me, again tells us how far we've gone. By the way, all of these things, again, I think were articulated by people who really thought that they were trying to prevent harm. They were trying to prevent not just insult, but things that actually cause harmful behaviors. And it's true. Some people who believe that people with disabilities are incapable will then discriminate against the disabled in bad ways, or even decide to taunt them or physically abuse them. Some people who believe that ethnic or racial groups are less ambitious, less hardworking, talented, or more threatening than other groups, obviously have done very bad things as a result of that. Those are very serious concerns. They do not, it seems to me, it seems to me, an adequate justification for restricting speech. Let me close with one last thing, because I do want to say something, do want to acknowledge the defense that the university gives, because often these days we're hearing people say, we're not trying to ban this speech. We're just trying to counter-speak, and there's a lot to be said for that. And look, the university even said in this draft proposal, this statement shall not be interpreted to prohibit certain kinds of scholarship and teaching-related conduct by faculty or educational expression of students in classrooms and public forums. But read carefully what's going on there. Look, so it's not designed to restrict this speech by students. Well, what about speech outside of classrooms and public forums? Read literally, this means that if the speech is in, say, a lunchroom, or in a conversation in a dorm room, not a public forum, not a classroom, well, then it sounds like that really is something that might be potentially punishable. And certainly if we view this as violating a person's right to work free from expressions of intolerance, why wouldn't it be punished? And again, returning to what I said a little bit before, it's easy for us tenured faculty members to speak out against this and to disregard this and to say, well, of course, I'm protected by these safe harbors. I'm a tenured faculty member. I can do whatever I please. That's a very normal reaction for us to have. Not so normal among lecturers, among untenured faculty members, as I said, among grad students, among undergrads, who might be in a position where they have to apply for various things that the university has just told them that their speech, that if they engage in certain kind of speech, that's a violation of rights, that's a violation of university principles. That kind of censorship, it seems to me, can be almost as insidious as the outright speech codes, and unfortunately also much harder to challenge in court. And with that, I close.
I thank all the speakers, and I'm going to pose a couple of questions to the speakers, and then open matters up for the audience. But something that I'm wondering is, what is it we're talking about? Are we talking about First Amendment doctrine, or are we talking about campuses? So there's a lot of discussion of Supreme Court rulings defining what kind of speech is sufficiently harmful that it can actually be suppressed. And there are certain categories. Incitement is the one that Thane was principally talking about. There's also true threats. There's also fighting words. There's also hostile environment, which actually individuals can't violate that. That's where an entire institution is so pervaded by pervasive and severe statements that the entire environment is discriminatory. So there's certain, but each of these is very narrowly defined. Maybe they are too narrowly defined. I know, Robert Bork, one of the reasons he was dinged for the Supreme Court was he believed that Brandenburg against Ohio was too high a burden, too high a bar for punishing inciting speech. That we need to be able to punish speech that incites violence against vulnerable groups before it's imminent, right? As it's building, he said, that's when you need to stop it. And so maybe Robert Bork was right, in which case we ought to be rethinking First Amendment law across the board, not just on campus, but across or maybe what we're talking about is the special circumstances of universities where people, after all, live and they're trying to study and they're captive audiences and so this is what I'm interested in, or at least as a clarifying question, is this across the board, or is this a campus university sort of policy that we're talking about? Maybe I could ask Thane to begin, and then some others would want to jump in.
Well, Michael says that because he knows what I'll say. I'm in favor of a massive overhaul of the First Amendment, so I could be very clear. Massive overhaul, a complete rewriting of the thinking of the doctrine with the recognition. It was interesting when Catherine I wrote when she said, you can't be protected against, again, offensive words, and my notes were, yeah, but you should be protected against acts of violence delivered in words and gestures, right? That to me, it's the same idea that think of it in terms of acts of violence that are being delivered not with a baseball bat, but with words and gestures. And when Alex used the phrase, I love it, was reminded of something that I think that Greg reminded me of in the Atlantic article when he used the words that, don't forget that the Tutsis were referred to as cockroaches by the Rwandans. And I would say, yes, exactly. And if I was a Rwandan student of Tutsi origin and I was studying in a university and someone called me a cockroach, I would hope the president of university would recognize the context of that, which is very different from years ago. I think it was 1993. And I think, Greg, you mentioned the water buffalo incident.
Yeah, that's 93.
That was 93 at the University of Pennsylvania. I'm so old, I remember all this stuff. But in 1993, an Israeli student who was trying to study one night was at his dorm, and there were a lot of people who were making noise. They came back from a frat or sorority party. They were doing what people do, even at the University of Pennsylvania. And so they were making a lot of noise, and he reached out the window and he said, "Shut up, you water buffaloes." And of course, it just so happens they happen to be African Americans. And as Greg pointed out, I don't even understand how I don't even understand how water buffalo is a racial comment, but somehow that student is gone. He had to withdraw from the University of Pennsylvania, right?
Actually,
whatever happened to him?
Well, what happened was it led sort of indirectly to the founding of FIRE, because the person who ended up helping him out the most was Alan Charles Kors, who became one of the founders of FIRE in 1999. But he did successfully defend the student, but they wanted to kick him out.
Yeah.
And with a combination of the local ACLU and Alan and a national, even Doonesbury was saying, like, what the hell how is water buffalo a racial insult?
Okay, but cockroaches.
He graduated from Fordham Law School.
Yeah.
That's right. I should know about him because I was there at the time. Actually,
But then I gather a case like, I think one of the most famous free speech cases was the Nazis marching in Skokie, where Skokie, for those who may not know, is the largest concentration of Holocaust victims in the country, and the Nazis marched right through the middle of it. I take it that was wrongly decided.
not only was it just,
And by the way, there's no shock in
despicable.
my voice.
Yeah,
that's a perfectly reasonable
This is a
position,
despicable
but-
opinion. I'll tell you why. Read it. Collin versus Smith. There's a footnote in Collin versus Smith that said the following, just to show you where the heart is when it comes to the First Amendment and the way judges understand it. There's a footnote in that case in which the judge said, there's no evidence in the record that the Holocaust survivors, he didn't refer to Holocaust survivors because in 1977, that wasn't even a term of art. So there's no evidence in the record that the Jews of Skokie were going to respond with violence to the neo-Nazis. And so therefore, because there's no evidence, again, this goes to Shaplinsky doctrine, right? That they would have been inspired to punch back, right? To go off with bottles and sticks, as Woody Allen says in Manhattan, and teach Nazis, because that's how they really understand things, bottles and sticks. They said, since there's no evidence in the record, then they would. The Jews of Skokie should just sit home and shut the blinds, right? Because the rights of the Nazis should supersede the rights of Jews, survivors living in Skokie, to live free from being re-traumatized by goose-stepping Nazis. Now, by the way, the courts would never say to the Nazis, you know, goose-stepping through that town is not an idea, it's not speech, it's just violence. You want to have an idea about Jews, write an op-ed in the Chicago Tribune. You want to say something? This is not the way to speak in our society, dressed up like clowns and marching through a vulnerable community.
Yeah, I should say I have a very similar view about the communist era cases. I mean, I think Frankfurter had an excellent point. Here, these people had butchered tens of millions of people. This happens in China. They were about to butcher tens of millions more, and they wanted to bring their filth to America. They wanted to line up the kulaks against the wall and shoot them, just like they did back in the home country. And there's no question that the American Communist Party, we know now for sure what at the time was denied by some, but what was quite clear. We know that it was controlled by Moscow. We know that it was, at the time, it was Stalinist. This was during Stalin's life. Stalin died in '53. So it's very easy, I think, you read those opinions, and you have to say, look, Frankfurter and Jackson had some especially the plurality opinions. Doesn't have, I think, the vigor of their writing. At the same time, I think the reason we protect, we think that those cases are mistaken, the reason that we protect even communists, at least in my view, just whenever I see a Che t-shirt.
What?
I've never read any history.
Yeah.
But in any event, the reason we protect it is we saw that when you start trying to restrict that kind of stuff, you start restricting more. I think we heard some here. Well, no swastikas. Okay, well, no Confederate flags. I don't have any truck with a Confederate flag. I don't have any respect for it. I certainly see why people are offended by it. But to say that you cannot wear a symbol which many people view, and I think quite plausibly, just as others view it associated with slavery, they view it with their sense that the South has gotten a bad rap, and that Southerners have been insulted, and that they need to be proud of their identity. Again, it's not my view, and I'll be happy to criticize it. But as I understood it, the argument was the university should have the power to censor that. I mean, I think we say the same thing with the Trump chalkings. Look, Trump, I don't like Trump at all, and I don't like the things he says about a lot of groups, including illegal aliens. So I think by and large, people are just trying to make a better life for themselves. It's an interesting question what to do with regard to illegal immigration, and I'm not a fan of open borders either, but I think these are interesting questions. But again, you try to suppress the extreme stuff, you get to the point where, well, it's harmful. I'm not saying that a thing that you think that, but certainly people think that it's harmful for me to see something chalked at my university which expresses support for someone who's apparently supported by about a quarter of the U.S. population.
So Alex and then Catherine.
Thank you so much. So a couple of things. I don't know where to start because so many points were made. Perhaps the best place is to start with the point that Michael made about Bork and rewriting. First of all, I think Brandenburg is just misinterpreted. Right? Brandenburg was a very particular case. It had to do with the Ku Klux rally. It had to do with the Ku Klux Klan rally at a farm where everyone who was there was either a member of the Klan or two people were invited there. Nobody felt threatened. There was no imminent threat.
Plus the television reporters that they invited in, and so it was then broadcast in the community.
Yeah, so two people who were there who were invited and didn't feel threatened. There was a cameraman and there was a reporter. And so, of course, there was no imminent threat of harm. But then we get to Virginia v. Black, which is also a cross-burning case, which is seen in the public, which is seen both from the road and by a woman who was sitting on the stairs of her in-laws' house. And we have Virginia Black that, in fact, cross-burning can be prohibited if it's intended to threaten. So I think there has already been a reconceptualization of the doctrine. The claim is there's just a difference between incitement and true threats. In my opinion, it's just the court not wanting to be honest about the fact that it's already reconsidered. Hang on, let me just, I just have a bunch of stuff. On Collin, which did, in fact, Collin did find that it upheld the prohibition against, there's a long series, several cases, okay? At the very end, the Nazis could not march. By the way, they never did march in Skokie. They marched in Chicago. They put off even though they were allowed to. Another curious thing is that the United States Supreme Court never ruled on the substance of that case. They only ruled on procedurally, that there had to be an availability to appeal a injunction against a march when it came to the First Amendment. That's all. The Supreme Court said there had to be, there was a 3-year process of appealing the injunction. The court said that's too long, we're dealing with the First Amendment. So what happens in terms of rethinking the First Amendment? Justice Roberts takes this case, the Supreme Court case, which is purely procedural. Read it, it's one paragraph, won't take you long. And he says it's been decided that you cannot prohibit Nazis from marching in Skokie, it's speech we hate. He creates substantive doctrine out of procedure. He just makes believe. It's not even dictum. All it is now his is dictum. It's in McCutcheon. That's where you can read it. A case dealing with campaign finance. He just creates doctrine out of whole cloth. It's amazing, and he cites to the Supreme Court case, not to the Seventh Circuit case. And then on Eugene's point, we have to differentiate between the communist cases, don't we? Between Dennis, where they seem to be involved in participating in advancing violence by communism, and Abrams. These guys are just putting out a Yiddish pamphlet about opposing the U.S. involvement in the war. So the problem with the communist era, it seems to be, is the witch hunt. Not that there was a prevention of serious threats of violence, but rather that many of the people who were drawn into it had absolutely nothing to do with any violence. They believed in communism in the abstract, socialism in the abstract. That those were distinct.
Catherine?
Yeah, there's so much.
And then we're going to open to the,
okay.
After Greg, we're going to open to the crowd, so you can be coming down to the...
Okay, I want to weigh in on Skokie because to the extent that it's a substantive decision, or that it has long been interpreted as a substantive decision by other judges, I thought at the time, and I still think, that it was correctly decided. And I say that even though when my father was growing up in Europe, in the free city of Danzig, which is today Gdansk, and he was walking his younger brother to school, Nazis were throwing rocks at them, and then the schools were closed to Jews, and my father was sent away to boarding school because there were no schools where they were living. And my family, we were all talking about, incidentally, this rule, you can't ask people where they're from. We were all talking about where our families were from. And my family fled the Bolsheviks, and my grandmother's sister was repatriated to Siberia. So I hate communists and I hate Nazis, and I am well aware of
but
the
hate
real
is not
harms.
an idea, so we won't talk about
I was clear on that.
Yeah, okay. So, speech does lead to actions that harm. But that said, what I learned at my family's table was the wonderful things that we got when we reached the United States and could become citizens. And one of them was the guarantee that we could speak our minds, and almost the obligation that we do so about important things, and that we be active citizens. And that's why, even with all of the emotional baggage that surrounded the Skokie case, I never thought that the ACLU had made a mistake in supporting the Nazis, and it really harmed the ACLU for decades in terms of contributions and so forth. There's no question, to go back to Alex's presentation, that schools and universities can ban and punish speech that can be banned and punished off campus. And most of the examples you were giving are speech that is outside the protection of the First Amendment. But when we talk about the hostile workplace, speech by fellow workers, that is a situation where the federal government has instructed private actors, not bound or constrained by the First Amendment, that they must discharge offensive employees. That is not the government itself making those termination decisions. So now, are universities in any way distinctive? And here I have to say that even with my very hardline First Amendment approach, absolutist some might call it, I think there are a lot of things that schools and universities can do when confronted with noxious and vile speech that do not involve using the coercive power of the state. Because here, if we think of the university as the state, whether it's the public university or the private one, the university has messages of an educational nature that it wants to give to its students. And even in the university where the students are adults, they're in some transitional sort of situation, which they are no longer under parental guidance, we no longer have parietals, which were imposed by quasi-parent institutions, but they're still there to learn from adults. And I don't say that in the way that Justice Black said in his Tinker dissent. We're not there to learn from the loudest young people. But, within that, I think that a university president is well within the traditions of the First Amendment to counter bad speech with more and better speech of his or her own and say, this isn't the kind of community we want to be. We're not going to punish you, but I want to talk about an incident that happened here. We have a viewpoint that gives value to the 14th Amendment values of dignity, equality, respect, and equal treatment, even as we must support the First Amendment rights of those who have different views, but we have a preference in our community. And I think that universities are special in their ability to deliver some of those messages, as well as to show the acceptable ways, not acceptable in the terms of civility. I think Joan Scott has written very powerfully about this, that objections and dissent aren't always civil, but that, here is the right way. Demonstrate outside, don't stop the speaker. I suspect that Greg will differ with me on some of what I've just said in terms of the university message, but I'd be interested in hearing.
Well, great, and what I want to say is listening to this panel has been fascinating for me, and I feel like part of the crux of the disagreement is how we think of First Amendment law and how we think of the American interpretation of the First Amendment. Now, the real difference that I see more than anything is between most of the rest of us and Thane's opinion, because I'm used to debating Eric Posner. He seems to be like one of the only people that I routinely debate. And when he gets frustrated with me, he immediately calls me a free speech absolutist and a free speech fundamentalist. And I have to explain, no, there aren't any free speech absolutists who are constitutional lawyers that I know of. We all believe in the categorical approach. We believe that intimidation, threats should not be protected. We probably all believe that child pornography should not be protected. We might be a little iffy on obscenity. Definitely Brandenburg, you can differ on if it's actually but certainly conspiracy to commit a crime. To me, First Amendment law is the best thought out, longest meditation on how you maintain a pluralism of opinion and genuine and a diversity of opinion and pluralism in a diverse society. And so my parents are both European, so I don't share the sort of Europe worship that I sometimes run into on campus. When I go over there, I feel like they're completely stumbling over themselves trying to figure out how to come up with a principle as simple as, okay, we have lots of different rules, there's lots of different ways we can curtail speech that we think is harmful, but we do have one bedrock principle, to borrow a phrase from Texas v. Johnson, that offensiveness cannot be that goal. It cannot be that standard because it is too damn slippery. And so it's interesting the way we actually treat it in First Amendment law, that we do really, that pure opinion is almost always protected, and I believe it almost always should be. But at the same time, the kinds of speech that aren't protected, for example, FIRE has no problem with true harassment being protected on a college campus. But this is why I bristle at the idea that kind of like these free speech absolutists, they believe that they're...
Greg, what I really wanted to know was...
Oh, sorry, I was addressing something different.
And I'm apologizing now also to Michael because I might have usurped the moderator's position, but I wanted to know if you would agree that the university president can say publicly, this isn't the kind of community we want to be, but you have a right to say it.
Oh yeah, well yes. Oh yes, with a caveat though, and I've had this discussion with Erwin Chemerinsky. They can, but they have to be careful because part of the goal of being a university president is to create this forum where people can say, I can come here and I can disagree. And every time a university it's in the Calvin report, which you cited, it says that it is a little bit of a danger. Every time a university president takes a political position and says, well, this is what, at this university we believe in, affirmative action, or we believe in liberal values essentially, they do seem to be sending a message that there's an orthodoxy at this college. Now again, FIRE believes that university presidents have the right to do this. We do think they should think about the orthodoxy they're creating when they do it and use that power sparingly.
So now, yes, Joel.
It's not on, it's off. Oh, there we go.
So, a quick comment. Greg started off talking about how people talk about the issue of speech on campus from a political standpoint, and then didn't seem to want to discuss the issue further. You seem to think like it wasn't an interesting subject.
Oh no, it's an interesting subject. Just I was trying to pierce stereotypes though, and say that it's usually more complicated than that.
Okay, but to me, it's not a stereotype because I do think that a large majority of campus professors left.
Yeah, that's a fact.
And it also seems to be the case that efforts to shut down speech come from the left against speakers coming onto campus from the right, and almost never the other way around.
Well, I mean, just to clarify what I was saying, yeah, political correctness is a real thing, and I write about this all the time. I don't love the term political correctness, and and if censorship comes from any direction on campus, given campuses lean decidedly to the left of center for the rest of the country, yes, of course it's coming overwhelming from the left. My point was that a lot of times people miss that the natural tendency of this is that this ends up being, in a lot of cases, used for apolitical goals, where essentially a president or administrator just doesn't like you, just doesn't like what you have to say, and wants to figure out an excuse for punishing you. So I basically think that everybody always acts with mixed motives, and I think that's one of the legitimate complaints about sort of like that Jonathan Haidt brings up a lot, that you have universities that are too one party, that you don't have enough people saying, hey, wait a second, maybe we're actually all groupthinking here right now. I think that's a very real problem, but I did want to make the point ultimately that sometimes that I get frustrated that there are a lot of cases where people that have been on campus because they don't fit that political narrative that Fox News doesn't want to hear about and MSNBC doesn't want to hear about it, and I do find that frustrating.
I will give one example of something which comes, you tell me what the politics of this is, but there's been an attempt to suppress anti-Zionist speech, and it's come mostly from particular Jewish groups, unsurprisingly. I hesitate to call them conservative, but it's not sort of traditional left on right speech restriction. I should say I support Israel. I think it's a lot better than most of the other countries in the area. But at the same time, it seems clear to me that it should be just as much subject to criticism, or even vitriolic criticism, as any country, as any government. There was a particular proposed resolution that the regions at first were urged to do, which would have adopted the State Department definition of anti-Zionism, which includes supposedly holding Israel to a double standard, which incidentally, I agree, I think a lot of anti-Zionists do, but they should be free to do that, and this isn't something that universities should be condemning. So I think that's an example of that. I think there may be a little bit of what I call censorship envy going on, which is the more restrictions there are on speech that other groups find really offensive or really harmful or hurtful or damaging, the more other groups will say, well, wait a minute, shouldn't we be treated the same way? I think we heard a little bit of that with regard to anti-Semitism. I will say that discrimination against Jews has been long understood as covered by the existing anti-discrimination categories. I don't think you need an extra anti-Semitism one. There's case law on this that's actually pretty thorough. But I do see that a lot of those groups, I think, may have said, look, there are all of these things that are being said with regard to race or sex or supposedly Islamophobic speech and so on and so forth that's being suppressed. Well, we should suppress anti-Israel speech as well.
But that's inaccurate. That's an inaccurate portrayal. The State Department definition does not say that one cannot criticize Israel. It says, I have it. I'm looking at it right now. It says you're talking about an example they have, but they're talking about accusing Jewish citizens of being more loyal to Israel or to the alleged priorities of Jews worldwide than the interests of our own nation. That we used to say about Robert Kennedy, didn't we? You say that about Catholics, about Robert Kennedy. We all knew it was anti-Catholic. And this is just a definition of anti-Semitism, accusing Jews as a people of being responsible for real or imagined wrongdoing committed by a single Jewish person or group, the state of Israel, or even for acts committed by non-Jews. That is anti-Semitic. Hang on just a second. Okay. The proposed rule was not to punish anyone in the University of California system who would make these comments, but rather just as a statement of anti-Semitism. And in fact, the adoption, I think, was a good rule that it's not criticizing Israel. It's the demonization and the dehumanization and the hyper-stereotypization that's involved.
So here are the particular statements in the proposed
those are examples. That's not the actual definition. Those are examples.
Fair enough. Specifically, what they're saying that what the proposal was that the university publicly condemn and essentially say there's no place at the university for instance, drawing comparisons of contemporary Israeli policy to that of the Nazis. I think those are ridiculous comparisons.
But they're not censoring. And that is in fact true. To insult blacks about affirmative action and comparing it to slavery would be an insult. This is an example of anti-Semitic insult.
May I suggest to get away from the specific example, and I think the interesting sort of general question here is when a university officially declares that it as a community stands for certain propositions, does that raise any kind of a First Amendment problem at all? Does that cause a chilling effect that we should be concerned about for those who might not share
How about
that?
mandatory classes on white privilege, which occurs at many universities? We haven't talked about white privilege classes.
Yeah, and I generally don't think of it so much as a First Amendment issue as more of a academic freedom, sort of good good pedagogy question. Because the more narrowly you define what a university is supposed to stand for, the more you limit the universe of what's considered to be legitimate discussion.
And so, Alex, do you agree with that?
That discussion should be limited? No, I think it should be...
No, that there's something troubling from an academic freedom, even if not a free speech point of view, with universities declaring these are our values, and if anybody disagrees with them, we're not going to punish them, but they should know.
I think the government, as Helen Norton has pointed out in her writing, government makes all sorts of statements indicating that the Civil Rights Act of 1964 is a statement of governmental values. Why can't the university have Title IX against sexism is a statement of governmental values?
So let's say the university were to say, all of this stuff that criticizes America, it's just anti-American. Yeah. It's just awful, and we can't really ban it because the First Amendment bars us from banning it. But there's no place at the university, by the way, incidentally, a lot of these things are famous. There's no place at the university for anti-Americanism and hostility to our great country. And we just want to say it's a violation of people's rights to be free from this kind of harmful hostility. We just want to tell you this. And how would you react? I mean, it's been a long time since any of us were on tenured faculty members. How would any of us, well, Greg in particular.
I'm an adjunct.
Actually, Greg is an excellent example because he does teach as an adjunct. How would a lecturer react to that? How would an untenured faculty member react to that?
I completely agree with Eugene on this point. But that is a mischaracterization of the UC policy. It says that
He's
certain.
giving a
I'm not saying
hypothetical. He's giving a
Oh,
hypothetical.
well, that seems like that would be absurd. To ban criticism of any country would be a gross violation of the First Amendment.
And what about, but you said, but that's not a ban. You said, well, it's different because it's just the university making a statement.
Making
Well,
a
my
statement,
hypothetical
yeah.
was also the university making a statement. It was just a statement that says, we condemn in the strongest possible sense anti-Americanism, and there's no place at it, but, we're saying we're not going to actually apply any speech code.
So I'm going to intervene and suggest that we take another question.
Yeah, that's fair point. That was all one question.
With one caveat that Catherine will jump in
Yes,
first
Yeah,
quickly.
I just want to say that when I outlined the kinds of things a president could take a position on, I was specifically thinking of things that have a force of law, 14th Amendment dignity and equality, or things where the federal law already has taken a very strong position, like gender equality, sexism, even persons who already have the disabilities that we might all someday have, the things that have a stamp about this is a countervailing official government value. Now, when you get to things like patriotism, the flag cases and Barnett, one of my favorite cases of all time, where Justice Jackson said about the protections due to those who choose not to salute the flag in school. This is a hard case because the flag involved is our own. But even here, the right to differ, wherever it comes from in your belief system, is protected. So obviously we have a clear message in our jurisprudence that in the United States we cannot demand patriotism.
So there is no right to differ about sexism? There isn't a right to differ about, for example, whether
No,
the
not a
courts-
right to differ, a right to, and there I said, the president, what he can say is, we don't want to be a community that behaves like this. You can say, we think Title IX is horrible. We think it has no basis in the Constitution. We think it's an assault on liberty. But on our campus, because we have things like Title IX, we would prefer that we speak respectfully about gender. You don't have to. But the body politic here won't applaud you for what you're doing. So because you have the right to do it doesn't mean you to say it, doesn't mean you should say it. The Nazis could well have chosen another place to march. They chose Skokie intentionally to go where it would inflict the most harm. So I think these are delicate lines, but I'm not saying the president should adopt political standpoints like this university is not for Trump.
Right.
Okay?
Well, that
that
would
would
be a violation of the law. I
be
mean, that
really,
violates their
yes,
nonprofit status.
yes. But somewhere in the middle there are things also that probably
Sure,
the president should not take a position on of that sort.
Hi, everyone. My name is Doron Dorfman. I'm a JSD, which is a PhD in law here at the law school. I'm originally from Israel. Huh. So, yeah, I just...
Sure you want to go there?
Yeah, exactly.
You're really sure?
Yeah. I'm going there. I'm going there.
You're not
yes.
there yet, so you can step down. At some
I might
point.
step down, right? Okay.
3 seconds, you're over the line.
So I really enjoyed that panel. I think this panel was wonderful, and all of you had such great things to say, but I had a few comments. I do disability studies in law, and I've been doing disability studies in law for the last 9 years. I have to say that I kind of disagree with Professor Volokh. I'm sorry if I mispronounce your name. I think the idea of temporarily able-bodied people is an idea that it's very easy to buy it. It's very easy to buy, and it's really actually was very hopeful in promoting the ADA, right? Because as you know, President Bush had some relative disabilities. Most of the people who supported the ADA had people who knew there were disabilities. In his book, Shapiro calls it the army of invisible people. You know, it's the invisible people, disabled people around us that makes us believe in disability rights. But having said that, I think that the regulation in the university about incapability is actually a good thing. I think people with disabilities all their lives encounter views and beliefs about their incapability. And I think it is appropriate to really think about the social dimensions of what is incapability. And universal design and accommodations and issues like that in universities can maybe, really restructure what is disability. So I really believe that by restricting or saying something about incapability might be very offensive to people with disabilities. Maybe we can talk about it as something that we as university don't do enough to include them. Maybe they're not as incapable, maybe we don't accommodate them specifically. So that's one point. The second point that I wanted to raise was about Professor Tsesis' comment about Jewish people. So here at Stanford, I'm a member also in the CSRE, the Comparative Studies in Race and Ethnicity, and we consider Jewish people as an ethnicity. I also teach a course on law and identity, because I do law and identity, and when I first taught the course, I had a group of people, and we have a group of students, undergrads, and they go about and they form groups of identity, and when we talked about race and ethnicity, I had a new group that I never thought I will have of Jewish people as an ethnicity. So I think that's like an interesting way to think about it. And thirdly, we just had an incident with Tzipi Livni at Harvard last week. I don't know if you remember that, and I'm surprised nobody actually brought it up, right? And that for me, as an Israeli, so when I'm here at Stanford and when I talk at Admits Weekend last year, I had a student who was admitted and came to me and asked me, well, as the token Israeli, as the token Jewish person, how is Stanford Law School in terms of Jewish people? Like, will I get offended if I'll come here? Will people tell me things? How is it going, And I thought that the incident with Tzipi Livni last week really exposed a lot of the situation.
Do you want to say what happened, or?
Oh, yeah, maybe you should say what happened. I don't know.
Okay, so a former cabinet minister from Israel, Tzipi Livni, was speaking at Harvard Law School, and a student got up and said, essentially, "You smell," which is a very
Smelly.
smelly. Yeah, you're smelly, and this, of course, was associated with hundreds of years of anti-Semitic accusations about the attributes of Jews, and there wasn't apparently really a response during the event, but afterwards there was an outpouring of outrage, and Dean Minow said, it's an offensive statement, but the person has a right to say it.
Exactly, and he wasn't, exactly, and I think, it really, when Professor Tsesis and Yo talked about, the penalties or, what's going to happen, I really thought about this incident, right?
Can I just add
sure.
one point? Because I only found about this, I didn't realize you were talking about the same one. I was just talking to Peter Berkowitz about this, and definitely this brings up at least interesting issues from a sort of open, transparency point of view. Peter told me that they did, Harvard did put the entire they put the entire speech online, but they took out the section where the Palestinian, where the person called the speaker smelly, which to me is the worst possible solution, to try to edit it out as if it never happened.
That's fascinating.
And at Harvard University, I don't know how many months ago, but there was all the black ribbon on the black faculty, issues as well. So I kind of wonder.
We don't know who was it.
Yeah, but I don't know how much. I don't know how much investigation went into it, and what happened, and how how much they actually invested in finding the person, who did it. Sorry, that's all my comments. Thank you so much for a great panel. I feel very privileged, to be part of the Constitutional Law Center and work with Professor McConnell and Judd. Thank you.
Well, thank you for your comments, but I want to defend my position on this. You said you feel that that the current disability law is good and perhaps it should be extended. You might be right. You might be right, or you might be wrong. It may be that in fact we are doing too much to accommodate the disabled in various ways. Maybe not, but how can you know one without knowing the other? how can you know one without hearing arguments about the other? And if you just say, well, it's just off the table, you can't say this because you said some disabled people may be offended. Of course they may be offended. But if this is something that the university says, essentially, this violates people's right to work free from these expressions, and the implicit message is when you're up for promotion or you're up for perhaps question whether you're being hired or not, we're going to keep in mind the fact that you have expressed these counter-orthodox views on disability. What essentially that's saying is once a particular battle has been won, the other side isn't entitled to say, wait a minute, this is a mistake, that this is one anti-discrimination category, whether it's disability or sex or ethnicity or whatever else, that shouldn't be such a category.
I wonder if, I agree with some of what you said, but I wonder how much unorthodox beliefs there are really about incapability of people with disabilities. I actually believe that the vast majority of people think and, you know, equates disability with incapability, and that's the problem. That's what I want to say.
Well, maybe a problem, maybe a reason you should argue against it, but it's not a reason to say, well, we think yours is a majority belief. So now we're going to say, essentially, again, the message being, if you express this majority belief, well, it'll look bad for you. It'll be bad for you when we decide whether to give you tenure or to hire you in the first place.
We'll talk later.
I just wanted to say just a 30-second thing about your point of ethnicity. I coined a term in my Destructive Messages book which Michael so kindly mentioned, called misethnicity. Not ethnocentrism, but misethnicity. So I've already, somebody would pick it up, but you know, the term is there.
Thank you.
Well, let's, Mr. Rizal, or Ms. Seaford.
So it seems to me, I'm Artemis Seaford. I'm a JD student here at the law school. I'm also a PhD student in political science. It seems to me so far the conversation has operated on three different levels. One is the level of First Amendment and constitutional protection. The other is the level of speech codes and regulation. And the third is the level of social norms. So my question is about the social norm sphere. I'm a graduate student here, which means I teach undergraduates. And I'm constantly scared that I'm going to offend somebody. And I'm constantly trying to find this fine line between pushing people on their beliefs and therefore inducing them to critically engage with them without offending them and causing them harm. So harm, I think here is the key word. It seems that nobody on the panel is a speech absolutist. Everybody sort of sees the line somewhere, perhaps at different points of the spectrum. But we use the word harm versus offense as if it means something. And I'm not sure what it means. On the one hand, it's a derivative notion. Things that we think that should not be uttered cause harm. On the other, we treat it as an independent standard that can guide what it is that should not be allowed. So here's the question. I'm talking about the sphere of social norms as an educator when trying to sort of find that fine line of when to defer to students' perception of harm versus push them. It seems to me that the trigger warning, microaggression, this whole new climate has a self-fulfilling prophecy element, right? So people not only use that as an upward management or as a power tactic, which they do, but they also experience it as harm. So harm has a cultural equilibrium dimension, right? So if that is the case, does that mean that we're now moving to a new cultural equilibrium where people genuinely feel they're harmed by microaggressions? And if we are to remain to this harm standard, then we have to defer to them and say, okay, maybe we shouldn't be so critical. We should sort of refrain from certain types of speech. So how do we use the distinction between harm and offense as an objective guiding standard and not something that collapses in the definition?
Yeah, so just Thane, can you start off?
I can, actually. Well, you know, it's an interesting question. Well, first of all, I think that most students don't refer to it as harm. They talk about being offended or hurt my feelings. They don't actually use, that's why you heard me keep saying the word harm versus offense, being offended. The students they're saying it correctly, by the way. They're not invoking the fact that they've been harmed. I'm saying that that's the standard. They're talking about that they're entitled to be free from being offended or for having their feelings hurt or to be insulted. So as long as they're getting it right. So I don't have any objection to that. And that's number one. Number two, you know, that's the reason I gave you the reason I jumped into that little humorous bit about Kanye West is because I thought that everyone in this room would go, yeah, I mean, the Kanye West thing is ridiculous, but if they had the same party and everyone was dressed in chains, that we would feel very differently. And that is harmful. And that is an attack on a community and a people. So, you know, we tolerate an incredible amount of ambiguity in the physical world when it comes to the legal system. People come into court wearing a neck brace, they're sitting in a wheelchair, and the jury's asked to make a determination on a personal injury case, and one doctor says, this guy will never walk again, and the other doctor said he could run the marathon tomorrow, and the jury has to figure this out. But we think when it comes to the emotional sphere that we're completely incapable of knowing the difference. And by the way, I think that's absurd because most people know what it feels like to be humiliated. And I just think that this idea of saying, I think I gave you those examples between Kanye West is because I think that people can, and I'm not providing a I know it when I see it argument, although it sounds like I'm saying that, and I am sort of saying that.
But not really.
But I'm not really doing that, but I understand it might appear to you that that's what I'm saying when it is sort of what I'm saying. But I mean that jokingly only because I think we do the same thing in the physical sphere. We don't know. We're still trying to find out the truth. But I think that there are tests of reasonableness, and we should apply the reasonable person standard. And I think that it shouldn't be purely a subjective eggshell skull test, that we should be able to see dressing up as Holocaust inmates in a concentration camp is something that is just morally vulgar and should be legally prohibited.
But the reasonable person standard is, in a sense, a majority, a cultural majority standard, right? Yeah. So we can live. Start living in a world where what is reasonable sort of changes, right? So does the standard then change with it?
You're very smart. Yeah. No, you are, because one of my earlier books, The Myth of Moral Justice, I talked about the reasonable person standard and its failure. Because for that very idea is to say it actually says what would most people do in a given situation. And do you ever meet most people? It's not good.
So I heard harmful. Then I heard humiliating, and I thought, okay, maybe we're getting at personal insults, which one might imagine the personalized be treated differently. Then morally vulgar.
Yeah.
Then the difference between Kanye West and ghetto clothes and possibly blackface and chains, as that's humiliating. And I try to think about something that I might be closer to me personally. I'm ethnically Jewish, and so I certainly have pretty visceral reactions to concentration camps. I would think it's morally vulgar to have somebody be dressed up as concentration camp victims, but I wouldn't think of it at all humiliating to me personally, and I don't see how that would be harmful. Now, the thing about Thane is you are a reasonable person, and we're
But I actually think that even though I said all those things, I think they're all different things. But that doesn't mean that there isn't a piece of harm that comes from humiliation. Well, that can happen.
But I understood you to say that somebody wearing the Holocaust garb, even in a context where it's perhaps especially in a context of where it's a party and it's supposed to be lighthearted, that is harmful because it's humiliating.
No. I wasn't.
I was saying. May I jump in here a second?
Yeah, I think it's just harmful.
I think non-existent hypotheticals like people going to parties dressed as Holocaust victims are not very helpful because nobody ever does that because it's not funny, it's not party-like. What we ought to talk about are the sorts of things that people actually do that other people find offensive, like the Mexican hats. That's what set off the Yale thing. And what I'm wondering is is there the Supreme Court introduces an additional element that no one has mentioned, which is whether the speech also addresses a matter of public concern, and so that when a lot of these things actually are politically tinged. And people are making a political statement that is also perhaps insulting. And I'm wondering, and at least in First Amendment doctrine, which is certainly questionable, but under First Amendment doctrine, when it is making a political statement, it gets a lot of slack, even if otherwise it's producing some harm. And I think a lot of these controversies on campus are like that.
Well, for me, one of the most interesting things is, I see so much classism in the idea of what ideas you're not allowed to say on campus. It's like I got to Stanford, I was like, wow, this is the biggest collection of rich white people I'd ever met in my life. outside of living in Geneva, Switzerland for 6 months. There's a strain in First Amendment law that I always try to remind people of, because I think it's some of the wisest about, and one of the reasons why we have these very different ideas than European ideas of freedom of speech. I think the European idea, the idea of Britishness, the idea of Russianness, or being or Frenchness for that matter, to me has always been a little bit absurd. And I've always liked this sort of strong pluralism idea that we have in the US, that essentially you can't expect an upper class person from Boston to be anything like a lower class person from Alabama, etc. But that actually has an embodiment in the law, and in some of the dissents in FCC v. Pacifica, in Cohen v. California, it's expressed as a majority opinion that our delicate sensibilities, our sort of conception of propriety, for all we know, someone could be dressing offensively to make a serious political point, but we just assume from our lens that because it's highly offensive to me, it should be stopped, which is, one man's vulgarity is another man's lyric, becomes very literal. I'm a huge hip-hop fan. A lot of the stuff that I listen to would be considered incredibly offensive, but it is also at the same time an expression of real human emotions. That's one of the reasons why I don't feel like I'm in the position to say you shouldn't say that if it is the way people really feel. So I always talk about this as being my iron law. And I think this is why sometimes censorship itself can be so naive, is that it's always valuable to know what people really think. And as long as that's true, it's especially valuable to know the bad stuff. And right now we have a college population that is doing something that my father would really condemn as an immigrant, that they're coming in expecting you to conform to their norms of propriety and sort of generally sort of upper class privilege about what you're allowed to say. And it's not supposed to, that's not the way people who are genuinely good about communicating across cultures actually ask. It's about, they should actually be trying to figure out where you're coming from and constantly trying to figure that out. But when we start imposing, these different kinds of norms of what's beyond the pale, we are necessarily taking on a cultural lens that tends to be pretty narrow.
So we have time, I think, for one more question, and Mr. Ezell has been very patient.
Thank you. My name is Trevor. I'm a 2L here. Thank you all for being here. I really enjoyed it. My question is hopefully pretty quick, and I think it's mostly for Professor Tsesis. So a part of what you talked about, I think this was particularly in the context of the trigger warnings, was the size of the problem. So a small number of schools within this country and then a small number of students within those schools. I think you said about 1% of schools actually have a requirement, and then 13% of students actually complain about it. I don't know if that's 13% within the 1% or 13% of students across the country.
It's how many professors reported getting comments.
Okay. So it seems to me like there's two possible responses to that. I'd just be interested in hearing your thoughts on it. And to me, it seems like a confluence of something like projection and vacuity, right? So that there's the fact of the matter is universities, even if it's only a small number of them, project something broader to our cultural about what is acceptable, an acceptable way to have discourse on campus. And it seems to me like campuses are still held up in the popular mindset as the vanguard, right, where thinking is being done. And so even if it's a small number of schools, they're projecting to the broader American society of what discourse looks like, even if it's a small number of them. And then within those schools, it seems to me that there's a vacuity problem, that even if the number of students complaining is small, they're very often the loudest, and there's a general timidity to address even the smaller number of students that are complaining about those things. And that may touch on what Professor Ross was saying about sort of downstream effects of poor civic training earlier in education. But my final thought is that both of those things seem very true to my experience here, where I recently shared something on my Facebook and was immediately subjected to 48 hours of vitriol and being accused of basically dehumanizing my classmates. And when I pushed back and said, do you really think that I think you're subhuman? I think people said back, no, that's not true. But if no one pushes back and no one's willing to have that conversation, the combination of this vacuum and this projection of what universities really believe and hold out to the community, I think it is a large problem, even if the numbers maybe don't look that way.
And a point of clarification, were you talking about the National Coalition Against Censorship survey?
Yes.
Yeah, I mean, I know them. I mean, Joan Burton's a friend. They even say that that's a completely unscientific study.
It's an empirical study of a limited class.
It was a survey monkey that you had to volunteer.
It was self-reported.
A self-reported survey monkey of like 800 people who answered it. They need better research, is what I'm saying.
So I don't think it takes large numbers to have a strong chilling effect. Once people read or hear about people at other campuses, people at their own campuses who have experienced vitriol, who have been called into the provost's office, who have been threatened with being suspended from their teaching position, they will be very reluctant to take chances. If we're talking about faculty members, if we're talking about students, your peers may say, whoa, I don't want to post on Facebook. Remember what happened, I'm forgetting your name, and I don't have the strength to push back if they go after me. So I don't really care how large the numbers are. I think the danger of the modeling and the perception of risk is something we shouldn't tolerate. And this also goes to First Amendment doctrine. There's no encroachment too small for us not to be worried about it.
I think you make a very good point, that there are also always going to be isolated people who are held out to the community and who unfortunately will have a chilling effect. But the same is true of sexual harassment law. The same is true of virtually any law. The same is true of people. I used to be a prosecutor in the city of Chicago. There were lots of people just taken off of streets under disorderly conduct statutes for absolutely no reason than the cops wanted to do a reverse sting for a drug bust. But that doesn't mean that the law itself is unjustified. There are lots of people accused of rape, date rape, falsely. That does not mean that date rape is not a valid, legitimate right. That it does not make people consider and concern themselves as to whether or not their behavior is proper. And so I generally agree. But the campus codes, are like, for example, I was talking about the University of Chicago. It just says you cannot defame individuals, you cannot threaten them. There are other ones that prohibit, prohibit messages, as I said, against racism and sexism. So the misapplication of law is not a justification, is not a statement against law, but against its proper application. I also want to just go back to something that Greg was saying earlier, and that is the European model. He's not really describing the European model. The European model agrees that you can make insults, even racial, even ethnic, if they are made in the context of political speech. That is why the Muslim cartoons were not prosecuted in the Netherlands. That is why Charlie Hebdo was not prosecuted in France. There has to be an element of direct hatred and something more. In fact, most cases, there were almost no prosecutions under the hate speech codes in Europe. As for pluralism, he's absolutely right, of course, the value of pluralism to speech. But we have a country just north of us, Canada, a country that's even more pluralistic than we, a country that speaks of pluralism more often in its Supreme Court doctrine, and they have a hate speech. They have hate speech limitations.
So first, I'm sorry.
I'm regret that our time is up. So could you please join me in thanking the panelists?